On 13th November 2022, President Yoweri Museveni assented to the Computer Misuse Amendment Act 2022, which was championed by Kampala Central MP Muhammad Nsereko. However, the act came with criticism citing the fact that it undermined the right of freedom of expression and speech that are fundamental human rights guaranteed by the 1995 Constitution. A panel of 5 judges of the Constitutional Court agreed with the petitioners, Andrew Karamagi and Robert Shaka, who argued that the Section 25 of the Act, which finds offense with any person who willfully and repeatedly use electronic communication to disturb or attempt to disturb the peace, quiet, or right of privacy of any person with no purpose of legitimate communication. The lawyers argued that the section restricts free flow of information and ideas essential to sustain the collective life of the citizenry in the digital age.
This is one of the most notorious sections of the law, and it has had the grave and dire consequences of leading to the exile of at least 2 Ugandans so far, and it has threatened the liberty of hundreds more.
The act was seen as a tool by government to gag the mainstream and online media. The Uganda Human Rights Network for Journalists has welcomed the ruling.
It's also a great boost to another petition that we have in the Constitutional Court that challenges Section 24, which introduces cyber harassment. We also think that it's another great boost to now the current amendment to the Act introduced by Honorable Nsereko. Because the arguments, the grounds, everything is the same literally.
The Uganda Law Society President Bernard Owundo explained what the ruling means.
It means that a judge faced with someone who has been prosecuted can no longer pass a judgment implicating or convicting that person for the offense under Section 25.
According to the ruling, the government is supposed to meet the legal costs incurred by the petitioners. However, according to Owundo, Parliament should pick a leaf from this ruling.
You must ensure that the law that you are drafting is not unconstitutional, meaning it must not restrict the rights and freedoms of citizens, except as permitted, of course, by the Constitution. Number 2, it must be properly defined.
The state has 14 days to appeal this ruling, but it's unclear if they will appeal against it.
Section 25 of the Computer Misuse Act has been described as being vague, disproportionate, and also unconstitutional. That means that any person who has been charged using the same section should be released, and therefore it remains a waiting game to see whether the responsible authorities are going to heed this call. Sidil Yarhanga, NTV.